All right, court does call the case of the people versus McLaughlin.
Hannah Mackey, hearing with and on behalf of Charles McLaughlin.
All right, very good.
Andrew Childers appearing on behalf of the people, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day.
That's correct.
Now he's here. And so you may call your next one.
Thank you, Your Honor. People would call Thomas Rob to the stand.
All right. Sir, please come forward to be sworn.
Take seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth?
I am.
State, spell your first and last name correct.
Thomas Rob, T-H-O-M-A-N, R-A-Q.
Sir, thank you, Your Honor. Sir, how are you currently employed?
I've been with Washington County Sheriff's Office
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back on April the 5th this year, 2025?
I have a license as a road patrol deputy.
Road Patrol Deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was.
Okay. And on that date and time, what was your shift?
Sorry.
What was your shift that day?
I was working day shift,
Okay. What time did you start?
8 a.m.
8 a.m.
I
Okay.
believe the 7:30 time was when the call initially came in.
Okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was.
Okay. And who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he'd taken a stolen vehicle report for that vehicle. He advised that he had gained GPS location for the vehicle from the victim. That it was pinging it, I believe, on Brookside, which was in the West Lowell neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard him call it on the radio.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble. There's some kind of accident that caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 Gray Ford Explorer. That was the vehicle in question, speaking of the neighborhood.
So as you're entering the neighborhood, it's exiting the neighborhood?
Correct.
Okay. What did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay. And did you have to turn your vehicle around?
No, I was coming right at the entrance to the side street with the vehicle. The Ford Explorer was coming out from. So
Okay.
I was driving directly at it.
Got it. And did you in fact then begin a pursuit of that vehicle? Okay. And that started in this West Willow neighborhood?
Yes.
Okay. What is the speed limit on the road there where you initiated this chase?
It's a residential neighborhood, so 25 miles an hour.
Okay. Did the vehicle pull over after you activated your overhead equipment?
No.
Okay. What happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Rob, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At what point did this chase terminate in any way?
Van Buren Police, assisted us with the pursuit, and it was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was at on the end of any forest roads.
And that's in Van Buren Township?
I believe so.
Okay. During, from the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Charles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record show so reflect.
And where in the vehicle did you observe the defendant?
He was exiting the driver's seat.
Okay. Was there anyone else in the vehicle?
No.
And what did you do at that point when you made contact with the defendant in the driver's seat of this vehicle?
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall correctly.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right, thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question,
Yes.
and you followed that vehicle for around 10 to 15 minutes.
Around there.
And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer
To
than,
the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway?
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars pulled to the side. Is that correct?
I'm sure some of them did. Well, usually people like not very good about pulling over.
And it would be safe to say then that some cars did not pull to the side. And at one point you had to even drive on the shoulder of the freeway. Is that correct?
Yes.
You don't know why some of the people did not pull over to the side, do you?
Well, without talking to them personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of those vehicles could hear the sirens.
I suppose so, yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over.
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
Right, can you redirect?
No, Your Honor, thank you so much.
Sir, thank you.
Thank you.
Your Honor, with Detective Rob's testimony, the people have no further witnesses, the people press.
Any witnesses for the defense?
None for the defense, Your Honor. Thank you.
All right.
Now, people would move to bind the defendant over as charged on the information before the court. I believe it is 5 counts, yeah.
Yes.
5 counts.
Mr. Brown responds.
Thank you, Your Honor. Your Honor, the court listened to the testimony previously from Deputy Phillips. It also heard the testimony from Deputy Rob. So the counts that we have that the prosecution is requesting for bind over are assault with intent to murder. That would be on Deputy Phillips. There's fleeing and eluding. That would be on Deputy Rob. There's receiving and concealing a motor vehicle, an unlawful driving away, and a resisting and obstructing causing injury. And I think that last one goes to Deputy Phillips. So I know it's been a bit, so we probably should go over what the prior testimony was. The testimony from the Deputy Phillips was that on April 15th, he was on road patrol. He'd gotten a call that a reference a stolen vehicle at the Marriott. He responded, had contact with the owner. The vehicle described as stolen was a gray Ford that was stolen sometime during the night. I don't know if we ever really narrowed that down to exactly what time that vehicle would have been stolen. That was entered into lien. At some point, they got to the cul-de-sac in West Willow where the GPS told them that the vehicle would be found. They first got there, they couldn't see the plate because the vehicle was facing them. I believe that when they pulled up, they were facing the vehicle. They were probably 20 to 30 feet away from the vehicle. Again, it was facing them. And while they may not have been directly head on, they were in front of them with their headlights facing each other. The officer testified, Deputy Phillips, that he could see that there were at least two people in the vehicle at the time, that they pulled up. But then once they came to a stop, they said they were going to conduct a modified felony stop. Deputy Phillips said to unholster his pistol. Two passengers then got out. And so two people got out of the vehicle. And they started walking away from patrol car as well as the vehicle that they were in. Said he couldn't see the driver at first. Later could see who the driver was at about 15 feet. Said he yelled to the driver to turn the car off. So I believe the car was still running at this time. This point, his weapon is drawn. He says that he stepped out away from his vehicle into a space. This is a cul-de-sac. And as the testimony was developed, there was a space between the front of his vehicle, where he was the passenger, got out, and a space in the street from where a vehicle could pass through. He said he got out, couldn't recall whether or not he raised his hand, but he did get out and he got into that space. He said he could see the vehicle, the wheels turning, and that the car then drove at him without veering. He had his weapon drawn. And the vehicle, once it got started, did not stop, drove at him, clipped him on the knee as he had to jump to move to get out of the way of the vehicle. It did say that the vehicle does not stop after that. I asked him if the driver said anything to him. He said that there was nothing said, no threats made or anything like that. He did say he had recognized the driver as Mr. McLaughlin. He then testified that he and his partner then got into the vehicle and left in pursuit. So what we have then is the vehicle stolen sometime in the night. We do not know, or there was no testimony given as to who drove that vehicle away. We do know when the vehicle is seen again, there are 3 people in the vehicle. And I'm not clear as to how much time has passed. It's been a few hours. So we don't know if the person who took the vehicle, drove the vehicle away from the scene, is even in the vehicle when it's reached at West Willow, because there's been no testimony given for that. If the court remembers differently, certainly they could say, but as I recall the testimony, they spoke with the person who owned the vehicle and they simply said that the vehicle was taken in the night and they had a GPS and they're able to track them. So at the time that the officers or deputies are looking for the vehicle, tracking the vehicle, they have no idea who has taken the vehicle, male or female, white or black, fat or skinny, tall or short. There is no description of the driver or the person who actually drove away with the vehicle. We just don't have that. But what we do have is 3 people who are associated with the vehicle. One person is in the driver's seat, and several hours that have passed since the vehicle was driven away from the spot. So let's go back to the first charge, which is assault with intent to murder. So based on Mr. Chalice McLaughlin driving at the officer who was in the space to which the vehicle must pass in order to leave the scene, based on him driving at the officer and hitting him, the prosecution is charged assault with intent to murder. Now, most of the time we see this is usually charged as felonious assault. In fact, every time I've ever seen this, it's been charged as felonious assault. And there is a reason that it's charged as felonious assault. First, in order to prove assault with intent to murder, prosecution must show evidence which would have supported murder had death occurred. And that's first degree. They have to show that it was a first degree murder because they have to, in this, back up. This is People versus Sis Medea. That's 167 Mich 210. They have to show that that murder, that had death occurred, it would have been properly charged with murder. So, second, let's go with People versus Todd, 186 Mich App 625, 1980. There must be an intent to kill in order for you to have for murder. For you to have murder, there must be an intent to kill. And this is what the prosecution is no doubt going to argue. They're going to argue, you know what, even if he didn't say, I'm going to kill this guy, I plan to murder this guy. And you have to have that. You have to have plan and motivation to murder. They're going to say, well, he created a risk so high that, and he knew the consequence. He knew if he hit this guy, he could die, that's going to be sufficient. And I think that would be the logical thing to argue, that the risk that he created with the knowledge of the probable consequence, that'd be sufficient. But the law would not support that. People versus Milton, 81 Mishap 515, 1978. There must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation. They have to show that. They have to show some plan, some motivation to kill this person. What you've seen is a motivation to leave, to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not
Good question.
the evidence is sufficient?
Good question. Because People versus Oster, 67 Mich App says, where there is no evidence of planning or motivation, bind over is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6 second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation. Right?
Thank you. I've not said that.
Well, I know you're not saying that, but you
I
are
think-
saying that the case law does not indicate that de facto says that there is not enough time because the time frame is not spelled out.
Right, the time frame is not spelled. That doesn't automatically mean that it's an issue for the trier of fact, because they still have some duty, Your Honor, to show that there was some planning and motivation. That's what you're giving, what you would, if you were to bind over based on what you have here, you'd be taking away their duty. You'd be relieving them of their duty to put that evidence in, and that's what they have at preliminary examination. They have a duty to show that there was some planning. You can't simply say, well, you know what? Since the law says that, there's no time frame, then hey, that's enough. They have to actively show that there was a plan of premeditation to murder. It's not simply, well, you know what? And again, if you couple that with People versus Milton, where even the creation of a high risk of death with knowledge of the probable consequences is insufficient, that makes their duty very clear, Your Honor. They can't simply just toss these things out without showing exactly what they need to show, and that is that there must be some premeditation, some plan to do so. They have an active, affirmative duty to show that. They simply can't say, well, what he did was risky, and that's enough. They can't say, well, since there's no time frame, that's enough. They have to show you that there was a premeditation and a plan. And the most likely thing that was going on here was Mr. Jackson was trying to leave the area. The officer got into that area, and in the 6 seconds that it got for him to get out of his vehicle and to walk into that space where the vehicle had the only space where they could get by, and they ended up hitting him.
Premeditation necessary for first-degree murder implied where it involves a police officer?
There's no exception for police officer. There's no police officer exception.
No. But where it becomes first-degree murder, it's implied. Because there are certain types of acts that constitute first-degree murder,
Right.
right? One of those would be the potential killing or the killing of a police officer, where the premeditation is implied.
So you're saying there is an exception for police officers with acts that
I'm not saying it's an exception. I'm just saying there are certain things that will constitute implicit premeditation from the standard definition.
So you're saying that there is a police officer, something that
Well, I
specifically,
don't know if you want to call it an exception. I'm saying that there's something unique as to police officers, such as it would be where a murder occurs during a first-degree CSC.
that's a felony murder consideration, Your Honor.
Well,
And I don't think
well,
that that's,
it can be, it can be that. But even when you're talking about it being murder, what you're doing is you're implying the premeditation necessary.
because it's a police officer, so forth. So what you're saying, in some clear,
I'm asked the question, isn't there an exception?
I do not believe there is. I do not believe that
Okay.
the law changes. And Your Honor, that's equal protection. My client is entitled to equal protection
I
under.
don't think it has any equal protection implication. It's just a question of whether or not under the statute that gives that there is an exception.
Well, it is
You're
equal
calling
protection.
it an exception.
It is equal protection in that my client is entitled to, and again, I don't believe that this exists. Certainly, we can research it if the court believes that actions.
I just asked the question.
Well, okay, so my response is, I do not believe that that is a thing. I do believe that that's a thinking and charging what in every other case is always charged as a felonious assault. I do believe that there's a thinking, and that's where the equal protection comes in. That's exactly where the equal protection comes
I
in.
don't know.
Because my
I
client
don't
is,
know if that's equal protection.
well, I'll explain to you why I think so.
Well, I don't need it.
Okay,
Because I
well,
don't think
you've
we-
rejected it up front. Okay,
I
fine.
reject it outright.
Okay, all right, fine. Well, Your Honor, then I have to say I reject the notion that police officers have some sort of protected status.
Well, you could reject it. I asked the question. You're saying
Okay.
no.
I'm saying
I'll
no.
hear from the
I'm
people
saying-
when they get to
When
that.
they get there. Okay, all right. So let's move past that. Let's go to the unlawful driving away. Now, as I recall the evidence coming out, and the court may remember differently, there was no identification of who drove that vehicle away. And for unlawful driving away, the person who drives the vehicle away, or
Yeah, but yeah, I hear that argument, but does it matter whether it was driven from the scene or from the hotel? Is it really gonna matter?
yes, because one is receiving and concealing stolen goods and one is driving away. The thief has to drive the vehicle away. If they put no evidence before you, let me back it up.